Welcome to our continuing YouTube video series on business contracts. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we will be discussing the aspect of not imposing unilaterally contracts on existing employees, partners, associates, contractors, and the like. Now, what I'm talking about is where you have a pre-existing relationship, typically with employees, can be with other contractors, associates, other individuals who are of, we say, a lesser stature in the business than yourself, whether it's as the owner, the president, the director of the business, the company. And for whatever reason you feel, well, you know what, it will be a good idea to have a written contract in place. We've been freewheeling about our arrangement, and I would very much like to have a contract in place with this particular individual. The challenge with that is that all too often, the individual, being the employer, the president, the owner, will unilaterally bring up this contract. It will state largely the same terms with respect to remuneration, compensation, benefits, time off, and the like. And then it will have laid out a whole series of contractual and legal conditions, given that that is the essence of a contract. But what is in effect happening is you are in effect imposing more on the individual by all these contractual terms. And there is no added benefit, advantage in signing off this particular contract. And this poses a potential legal issue that the courts have seen. And typically what that legal issue is that you, as the owner, the employer, the president of the company, are attempting to impose something, constrain the employee, and forcing it upon them without any bargaining ability. And because they are in the more, we call it subservient, reliance position, they find themselves effectively taking it on. Nevertheless, what they can end up doing is arguing at a later date. And you never know when this may arise. It may never arise, but this is what they may well argue, and they will have a solid ear with the courts because of case law on this matter, is that this contract was unilaterally imposed upon me. I did not want to sign off on it, but I had to sign off on it because I had to keep my job. Well, that is a problem for that contract being enforceable. And the courts take a very tough position in general with respect to this unilateral imposition from the party with the greater strength of a contract on someone else. So what can this result in? And what can an employer do to alleviate this issue? Well, what this can result in is, in a dispute, the contract can be thrown out. And then you are left with a common law situation and a disposition from the court of you as an employer not having properly appreciated the law, the rights of the employee, and being this overbearing bully on the person and not even having the benefit of the contract. Another potential aspect is that your lesser, more disgruntled, unfavorable employees can take advantage of it early on and argue that this contract that is being imposed upon them fundamentally changes the terms of their employment arrangement, such that they might argue that there is a situation of constructive dismissal, and thereby effectively argue for considerably greater payment from the employer should they decide to leave. And they make the determination saying that the employer has fundamentally changed the employment relationship by seeking to impose this contract, forcing the employee to sign off on it, and not properly negotiating it, not allowing the employee to get legal counsel on the matter, and thus take advantage of the situation where they can. Now, what might an employer do? Well, one of the first things that an employer should do before seeking to impose a written contract or a new contract on employees where they did not previously have one, or the initial contract or letter agreement was, and now in their determination, inadequate, is they should engage with knowledgeable legal counsel. That is first and foremost the top priority. And why should they be engaging with legal counsel? Because they can get perspective as to what the law is talking about. But say they weren't to do that, well, then they have to make considerations. One of the considerations they need to understand is that if they are going to fundamentally change the employment relationship, which does arise when you seek to impose a contract, is to take away the imposition. Instead, it needs to be more of a negotiation. It needs to be something that's accepted. And what do you do to create acceptance? You provide the opportunity for the employee, the contractor, the associate, to sign off on the contract because the contract provides for some slightly better remuneration, compensation, benefits, vacation time, or the like. By providing this additional benefit, you're providing a negotiated option. Also, you want to allow the other side the opportunity to properly review it and to engage with legal counsel. I trust you found this YouTube video informative. It is only a very introductory aspect as to the impacts of employment law with respect to imposing contracts and creating new contracts with employees. And as always, you should engage with knowledgeable legal counsel, as we have strongly recommended both here and every time we talk about these matters. Naturally, we have our own context, and we welcome you to contact ourselves with respect to those matters. Thank you.